Get ready. 3 seconds. 2 seconds. Start. This is an interesting litigation where the Union of India has questioned the stand taken by the state of Assam. Full stop. The state's appeal was accepted by learned single judge of the Guwahati High Court. Full stop. The issue is whether an application under section 438 of the Code of Criminal Procedure, 1973 could be filed in respect of offences contemplated under the provisions of the Railway Property Act 1966. Stop. A learned single judge held that the offences were bailable after referring to section 8 of the Act. Full stop. Para. In support of the appeal, learned counsel for the Union of India submitted that the learned single judge has not kept in view the provisions contained in section 8 of the proper perspective. Full stop. The High Court has erroneously come to hold that the accused had a right to get bail provided he was willing to offer surety/security. Full stop. It was held that only when the accused is not in a position to provide security or surety, then only he can be sent to the magistrate having jurisdiction. Full stop. It was submitted that effect of the proviso to subsection 2 of section 8 has not been kept in view. Full stop. Para. A bailable offence is defined under section 2D of the Criminal Procedure Code 1973. Full stop. A bare reading of the proviso to subsection 2 of section 8 makes the position clear that three situations are envisaged. Full stop. Two of the three situations are related to clause A of the proviso. Full stop. If the officer of the force is of the opinion that there is sufficient evidence or reasonable ground of suspicion against the accused persons, he shall either admit him to bail to appear before a magistrate having jurisdiction in the case, or forward him in custody to such magistrate. Full stop. Para. The controversy can be looked at from another angle. Full stop. In Schedule 1 of the Code, offences are classified. Full stop. Part 1 deals with offences under the Indian Penal Code, and Part 2 deals with classification of offences against other laws. Full stop. Undisputedly, the present case is covered by Part 2. Full stop. While classifying offences on the basis of punishments prescribed for offences punishable with imprisonment for 3 years and upwards, but not more than 7 years, it is provided that the offence shall be cognizable and non-bailable. Full stop. However, an exception has been made by section 5 of the Act, making the offence non-cognizable. Full stop. Except that exception, Schedule 1 of the code applies. Full stop. Under section 3 of the act, for the first offense, the imprisonment may extend up to 5 years. For subsequent offenses, also similar term is fixed. Full stop. Para. There are two options given to the officer to form opinion, that is, whether there is sufficient evidence or reasonable ground of suspicion against the accused persons. It nowhere deals with the right of the accused to get bail. Full stop. The third category is contemplated by clause B of the proviso. Full stop. It inter alia, provides that when it appears to the officer that there is no sufficient evidence or reasonable suspicion, he shall release the accused person on his executing a bond with or without surety, as the officer of the force may direct to appear, if and when so required, before the magistrate having jurisdiction, and shall make a full report of all the particulars of the case to his superior officer. Full stop. This category deals with a case where there is absence of sufficient evidence or reasonable ground of suspicion. Full stop. In such case, the officer concerned has the power to release the accused person on his executing bonds. Full stop. Therefore, the High Court was not justified in holding that all the offences under the Act are bailable. Full stop. Such view is contrary to the provisions contained in Section 8 of the Act. Stop.